As we've already noted, writs of certiorari are the most common way for cases to come to the Supreme Court, but they are not common at all in that of the more than 10,000 cases that are appealed annually to the Supreme Court. They only grant usually 70 to 75 of those cases, having granted 70 in the October 2018 term. And in fact, over the last 20 years or so, the number of cases appealed to the court has gone up, but the number of cases that they've decided has gone down. About 20 or 25 years ago, the court used to decide around 120 cases a year. So it's actually gotten significantly harder to have your case heard by the Supreme Court. So in this lecture, we're going to talk about the procedure that litigants and the court follow in deciding how to pick these cases. So let's talk about the procedure. In a civil case, either side can appeal. In a criminal case, only the defendant can appeal. But whoever appeals, they have to file their appeal within 30 days of the decision of the lower court, whether that's a state Supreme Court or the U.S. Court of Appeals. They have 30 days to file their appeal. And this is called a petition for a writ of certiorari. It's also simply known as cert, so if you find certiorari difficult to say, just say cert and everyone will know what you mean. The brief that they submit in asking the court to review the case has to be no more than 30 pages. So there's a 30-page maximum, and 40 copies must be provided. These are actual hard copies that the court still requires when filing an appeal. In addition, litigants have to file a $300 fee. Now, some people can't afford that kind of fee, particularly prisoners who may be in prison. And so the court does have a procedure called an in forma pauperis petition. These are petitions, special procedures specifically set aside for indigent litigants. And what this program does is it allows those litigants to waive the filing fee, so they don't have to pay the $300. And they don't have to submit 40 copies, they only have to submit 11 copies, the original plus 10 additional copies. And if they are actually incarcerated prisoners, they only have to file 1 copy. In forma pauperis petitions are not generally successful, but they do make up a fair number of the court's docket each term, usually about 10%, and in fact in the October 2018 term, in forma pauperis cases made up about 11% of the court's docket. Probably the most famous example of a petitioner who used this procedure was Clarence Earl Giddeon. Clarence Giddeon was in prison for a crime. He had not been able to afford an attorney, but he taught himself law and legal procedure while he was in prison. He filed a petition for a writ of certiorari to the Supreme Court, which they accepted, and in fact they decided the case of Giddeon v. Wainwright, which was the case that established that everybody has a right to an attorney even if they can't afford one. So it was a highly significant case in the development of constitutional law, and it was a result of an in forma pauperis petition. So after the side seeking review has submitted their brief to the court, the other side is then given 30 days to respond. But this is optional, and their brief is known as a brief in opposition. So this is optional in every case except for capital cases. When an individual's life is at stake in a death penalty case, there must be a brief in opposition, but otherwise it's simply optional. Just like the original brief, these can be no more than 30 pages, and again, 40 copies are required. And then the first side is given an additional 15 days to respond. So the original party can respond one more time in something known as a reply brief, And this too is optional in all cases. So the first brief is of course the one that sets everything in motion. The brief in opposition and the reply brief are optional, and in most cases there are not a brief in opposition or a reply brief. And the reply brief has to be 15 pages maximum. So after all of that paperwork has been filed, the Supreme Court then starts to work. Most of these cases, and remember there are 10,000 or so of them, most of them are reviewed over the course of the summer. That's what most of the summer is taken up to doing. But cases are added to the court's docket during the term itself as well. Now, once upon a time, there were few enough petitions that every chamber read every single one. But now there are so many petitions that they are simply divided between the various justices, and the justices and their offices and their clerks are known as chambers. So now, of course, just over 1,000 petitions are distributed to each justice for them and their clerks to work through, and that practice of dividing the cert petitions is known as the cert pool. Most of this work, of course, is not done by the justices, but rather by their clerks. Justices can hire 4 clerks each year, and these are typically the best and the brightest. And during the summer, their main job is to read these petitions and to prepare short memos for the justices. The memos summarize the case, and they'll make an initial recommendation on whether the court should accept the case for review or not. Once the memo is written, it is then circulated to all of the justices. So regardless of which justice you work for, the memo is intended to be read by all 9 justices, and in fact they will read them. And it's based on those memos that the justices will ultimately make their decisions. The process for deciding begins when the Supreme Court initiates what's known as a discuss list. The discuss list is exactly what the name would suggest. The discuss list is a list of all the cases that the Chief Justice wants to discuss. Now, this doesn't mean that he wants to review them, but they're at least interesting enough that he'd like to talk about them with the other justices. So the Chief Justice initiates the discuss list, but all other justices can add cases to the list. So this is a very egalitarian process, and anybody who wants to discuss a case can force a discussion amongst the other justices. So yes, only one justice is required to force a discussion. And then, typically on Fridays, the justices will meet in conference. And this is the room that they actually meet in. This is the Chief Justice's chambers, which is immediately behind the Supreme Court courtroom. And the justices meet here in this room in private. They meet on Fridays, and they are completely private. Only the justices are allowed. If they need something, typically they may need a law book or something like that, there is a clerk stationed right outside the door, and if they need something, the most junior justice will open the door and tell the clerk what they need, but nobody else is allowed in there. It's not recorded. And one interesting story is when Harry Blackmun was a justice, he was a huge baseball fan, and he would occasionally have his clerks feed him baseball scores, particularly at the most crucial games of the season. So at this conference, they discuss each of the cases on the discuss list, with the Chief Justice speaking and voting first. So the Chief Justice will talk about the first case a little bit and will indicate whether he would like to hear that case for review or not. They then go around the room in order of seniority. So after the Chief Justice speaks, they'll go to the second most junior justice, then the third most junior, and fourth most, and so on and so forth until they get to the most junior justice who speaks last. The Supreme Court operates under something that's called the Rule of Four, and the Rule of Four is very simple. It simply means that 4 votes are required to grant certiorari. So if 4 of the justices say that they want to hear a case, then the court will hear the case. Now, justices can vote to hear a case, they can vote not to hear a case, but they've got another option, which is to join 3. When a justice joins 3, this is a courtesy to a fellow justice. When a justice joins 3, what they're saying is that they're kind of indifferent about the case, but if there are 3 other justices that want to hear the case, they will provide the 4th vote. They will join the other 3 to provide the necessary 4 to grant cert. So it's a conditional yes vote. If only 2 other justices want to decide the case, then the court will not hear the case. So yes, they'll vote in favor of cert if 3 other justices want it. So this is the procedure as I've just described, summarized briefly, so you can take a look at this. But again, the petitioner has 30 days to seek cert. They file the petitioner's brief. The respondent then has 30 days to respond. That's optional, and it's known as the brief in opposition. The reply brief is then available for the next 15 days and can be no more than 15 pages, and that too is optional. And then the Supreme Court decides whether to accept the case or not by meeting in conference, and if 4 justices vote in favor, or if 3 justices vote in favor and another justice votes to join 3, then the court will accept the case, and then it will be scheduled for oral argument. So that is the procedure that the court follows. In the next lecture, we're going to talk about the politics of Supreme Court agenda setting.